Welcome to the Oakland Place Subdivision General Adjudication public meeting. I'm Blake Bingham. I'm the Assistant State Engineer over Adjudication. And before I do get started, first I'll call your attention or introduce at least my boss, Kent Jones. He is the State Engineer, otherwise known as the Executive Director of the Division of Water Rights. We also have sitting next to him Mike Handy, who will be our team leader for this particular subdivision. So he's going to be leading the people on the ground that are going to be evaluating your claims. And we'll get to that process here shortly. And right next to him is Randy Tarantino, who's a member of his staff. And then you've met some of our other staff. And then we also have Melissa Reynolds over here. She's from the Attorney General's office. We are her client, she works for me, I guess, actually for Kent. But if there are any attorneys that'd like to speak with her afterwards, feel free to approach her. Again, if I can just start off with kind of some rules of engagement, I want to make clear that this meeting is not mandatory. I know that you received a summons in the mail. The reason behind that is that we were statutorily required to do that, but the summons does not mean that you are required to be here at this meeting. Now, I encourage you to attend the meeting, but at the same time, if you get to the point during the presentation where you feel maybe you have nothing to learn from this, or your questions have been answered satisfactorily, please feel free to stand up and walk out. I don't think anyone minds. We're all busy people. We have places to be, so feel free to do so. And with that introduction, let's carry on. Here's the agenda for tonight. We're going to go over the adjudication process, talk about what a general adjudication is, why it's important. And we'll talk about the proposed determination process, which is a little bit of a nuanced aspect of the overall adjudication. And we'll talk about the significant issues that are specific to this area and the anticipated timeline. I do have questions for the end. I'm happy to answer questions throughout the presentation as long as they are general in nature, so they benefit everyone. If you have a question that is maybe more specific to your own situation, maybe you could hold that off to the end, and I'm happy to answer those one-on-one and probably give you a better answer. Otherwise, I'm going to feel rushed up here and probably not give you the answer that you deserve. But if you're not sure, raise your hand and ask the question, and we'll see where it lands, and we'll do our best to get it answered. So let's start off with what is a water right. There's a lot of confusion maybe about what a water right is and what it isn't. A water right is really the right to divert from a natural source such as a spring or even the groundwater table via a well or a spring and beneficially use the water. And it typically has a couple different features or aspects of it. It has a defined nature of beneficial use, which means that the beneficial use is really what it's being used for. Is it being used to irrigate a lawn or irrigate a field, irrigate a garden? Is it being used to water some stock animals? Is it being used for your domestic residence? So that's when we talk about beneficial use. Those are the types of things we're talking about. Oh, and I forgot to mention, this is being recorded and will be available on our website tomorrow once we get it uploaded. So and this presentation will also be available in PDF format. So don't feel like you need to take pictures of the slides. Feel free to do so. However, it might save you some time. This will all be available on our website. Another feature of a water right is a priority date. That in essence means where it falls in line of priority against other water rights, whether it's a senior water right or junior water right. And that establishes where it falls as far as who gets to take their water first, okay? And we can talk about that a little bit later. It has a defined quantity of water, and we typically measure those quantities of water in either cubic feet per second, what we call CFS is the acronym, or by a volume, an annual volume, and we measure that in acre feet per year. And so an acre foot is exactly what it sounds like it is. It's an acre in area and I'm 1 foot deep, and that's the volume with which we measure water in the state of Utah. Water rights also have specified points of diversion. Now, that's a fancy word for a well or maybe a diversion off of a stream. You might see a head gate or a spring. That just identifies where this water is being diverted from. So when you think of point of diversion, specifically in this area, think of wells, because that's primarily what we see in this region. And then a specified place of beneficial use, where this water right is being utilized, and we measure that with respect to the public land survey system. I won't get too far in the weeds on that, but if you have any questions, I certainly can happy to answer those later. All right, so a water right may be evidenced by, and this is probably your best indicator. We get a lot of questions of whether you have a water right. You know, we send these notices out to all property owners within that map boundary. And so we get a lot of questions, well, how do I know if I have a water right? And our answer is typically, well, you probably would know, or you might know if you see a well in your yard, and because you're generally either having to deal with it leaking everywhere, or you're turning it on, or you're using it, or you're dissatisfied with the pressure coming out of your hose because it doesn't provide enough water during August or something like that. So in a lot of cases, you probably know if you had a water right because it'd be manifested typically in this area by a well. There may be irrigation ditches and those other types of manifestations that come into play. But again, in this area, I'm not sure that I have come across any of those. There may be serviced by Salt Lake City. You may have water running down the gutter that you own shares to irrigate your lawn. So that's different, and we'll kind of talk about that here. So what a water right is not a share in an irrigation company. There is an irrigation company. What's the name of the company you're saying? It's really owned by Salt Lake via exchange, and Salt Lake provides this water out of, was it? Thank you. Parley's Canyon Water Users Association. I think that's the only one I'm familiar with in this area. It doesn't mean there aren't others, but they, in essence, own the water rights, and then they distribute that water to people who have shares in that Water Users Association. Well, people who own the ground but through Salt Lake City. So it's a little bit of a different concept, but typically irrigation company issue shares to shareholders who then divert water, but in this it's a little bit unique, and you can certainly fill them in if you have any questions on the peculiarities of this particular company. What a water right is not a connection to a public water supplier, so it's not your service connection that you get at the meter from Salt Lake City or from South Salt Lake City. They certainly have water rights. However, they are the ones who are obligated to file those claims and pursue this legal proceeding. And I assure you they are very much involved in this process and are taking care of their water rights. I rarely go a day without hearing from one of those municipalities with respect to this process. So they are well versed in this concept. So let's start off with a little bit of historical context. As I was talking earlier, it's really hard to talk about a general adjudication or water rights in general without giving a little bit some historical framework so you understand why it's important. And for those of you who have seen this presentation before or suffered through it, such as my staff, all the jokes are the same, but hopefully those who are seeing it now will maybe get a kick out of the historical overview. So we know the story. In July of 1847, Brigham Young with an advance party, Mormon pioneers came to the valley, and they started diverting waters from City Creek to kind of soften up the ground in order for some late season crops. They later built a shopping mall there. I'm sure Brigham Young would be proud of that. In 1848, Brigham Young kind of made this statement, which would really be kind of set the stage for future water rights in Utah. He said, "There shall be no private ownership of the streams that come out of the canyons. These belong to the people, all the people." So in Utah, water is not owned by people. It's not owned by the state. It's actually owned by the public. And we administer those water rights. So the Division of Water Rights administers the water rights, but in theory, the water is owned by the public, by all of us. From 1847 to 1850, Utah kind of went through these different phases. They went from being a part of Mexico, and then, of course, they had the Mexican War, and then went to this quasi-state of Deseret, an ecclesiastical state, and then finally to a territory of Utah. But through each of these phases of what we now know as Utah, people continue to divert water and use water. This concept of having water rights or appropriation was really an evolution as they kind of went through those different phases of being. And so as a result of that, diversions from water were typically made kind of on a communal basis. You could imagine Brigham Young or the Mormon pioneer leaders sending people up and down the valley throughout the state, and they would start diverting waters out of the creeks and start planting crops. And so they kind of evolved around that community. The doctrine of priority, remember I talked about a priority date. Well, the doctrine of priority kind of evolved from the church's recognition that the groups who first got there and put the first initial efforts into diverting the water and applying it, they had the primary right, and then follow-on settlers also had a right, but they had secondary rights. So once the primary settlers or the rights associated with the initial settlers were satisfied, then the secondary rights could be satisfied. And this is a system that kind of evolved and also kind of was further modified by the concept of mining claims, where you had a straight priority date associated with those claims. Also, conflicts were settled through ecclesiastical channels. You had bishops' courts would kind of act as a local judicial system, and then you had the stake high councils who would be kind of their court of appeals, right? If they didn't like what the bishop said, they'd take it to the stake high council, and they would make their decisions. As we kind of go on into the historic or into the territorial area, the first legislative assembly tried to get a handle on this, tried to kind of start to peel the power away from the LDS Church and maybe move it to a more a system of government. And so they authorized the county court to give all water privileges and timber privileges. However, Salt Lake County is kind of the only county that really abided by this. And I might add that the county courts were the same people who were the bishops and the stake presidents anyway. So really, in the long run, it didn't make a whole lot of difference. In 1877, the Desert Land Act was passed, and that was an act that was kind of aimed at prompting people to come and settle the West. And in order to do that, you needed some way to grow a crop, right? And so the outcome of this act was that it removed this concept of riparian rights, meaning you had to be next to a stream if you wanted to use that water, and it allowed water to be removed from the property. So you could clear over in Parley's Creek and use it down on 5th South now, right? So, but another feature of this, it also delegated the authority for the appropriations of these water rights to the individual states, which to us may seem kind of like a foregone conclusion, but if you think of like how the government land office, the GLO, operated, they're the ones that issued patents for homesteads. You would expect kind of the same thing for water rights. Well, this severed that, saying, no, the states can all figure out how they're going to appropriate water on their own. So you have different systems from state to state throughout the West who have adopted different ways of doing things. Well, in 1880, as I said, the 1852 Act really didn't have much teeth. They tried to fix it by appointing these county selectmen who would go and adjudicate water and recognize. But again, it was only really enforced in a few counties, and there was some issue with it being unconstitutional because it was delegating the authority to someone who wasn't over property rights, who wasn't a judge, right? They have a very kind of clean system where if it's a property right, it has to go through the judicial system. So there was some controversy over that. Anyways, it wasn't really followed either way. As a result of this, the confusion continued to reign in spite of the efforts of the territorial legislature or the church. And the church continued to administer and decree water rights. A classic example is the distribution of the Spanish Fork River that was made by a stake high council in 1879. So you can see that the church continued to exercise this authority in absence of any kind of real authority from the legislature, or the territory. Well, in 1896, Utah gains its statehood. There was a big to-do over what to do, big kind of controversy over what to do with water rights. There was some concerns that with anything put into statute at the time, that Utah would suddenly confiscate everyone's water rights, and no one would be able to use their water rights. And so they left it out. They decided, we're just going to punt, and the only thing we're going to put in the Constitution is that we're going to recognize any existing uses of waters. And so that's still in the Constitution. So if you were using water up to that point, it was recognized from there on out as long as you continue to use it. And so we call those kind of pre-statutory rights, and it was even extended further a little bit later on once we get into 1903, but we'll get there here shortly. In 1897, the Office of the State Engineer was created. So that's what we currently operate under. We're the Division of Water Rights, but we also have this other title as the Office of the State Engineer. And his responsibilities were to go out and map the state of Utah, identify where these stream sources existed. However, appropriations were still kind of made in the old-fashioned way, where you had to go kind of get your stake and you go pound it in at your point of diversion, then you had to go file it at the post office, and then file it at the county recorder. And again, those were kind of largely ignored. Every once in a while, we come across someone who actually finds their original claim that was filed at the county recorder. But a lot of the time, those things were kind of tucked away somewhere in the recorder and long forgotten. So those are pretty rare. In 1902, the United States Reclamation Service was created, what we know as the Bureau of Reclamation today, and they were given the mission of reclaiming the West through large-scale irrigation projects. However, they were really reluctant to come into any state and do any of these big projects without the state having some system of appropriation for some system of determining what water rights were existing, and also a system for appropriating new water rights. And so, as a result of that, it's no coincidence that next year, in 1903, Utah adopted its first major comprehensive water code, which provided for the recording of all existing water rights and the adjudicating of the rights by the court, not by the state engineer, but by the court. However, they failed to provide any funding to the courts to do that, so it was pretty much, again, largely ignored. They didn't really go in and try to figure out what water rights were on the books because the courts had their hands full with other stuff they were doing, and this was just an unfunded liability to them. In 1919, the state finally provided the machinery to kind of do this adjudication. That was the concept of this proposed determination. The state engineer would go out and do all the legwork. They'd go investigate all the water uses. They'd go investigate the claims, and then they would make their recommendation to the court. And then all the court had to do was give the bless off on that and issue a judicial decree. And this is largely the same system that we have today. So you have the state engineer who's part of the executive branch making a professional evaluation of these claims and making that recommendation to the court, but it's ultimately the court who decrees the water rights. And in 1935, so I might add that 1903, since that's considered kind of the beginning of our water law, we say any water that was diverted prior to 1903 from surface rights is pre-statutory, meaning it's grandfathered in. We often call those diligence claims because they were perfected through the diligent application of water. So if you had a surface water right, or if you were drawing from a surface prior to 1903, you have a water right by virtue of doing that. Same thing for 1935. Prior to 1935, you didn't need a water right to drill a well. After 1935, you did. So and this is kind of what is more pertinent to this particular group, is that if you had a well and it was established prior to 1935 and you continue to use that, you're grandfathered in. You have a pre-statutory right. And that's part of why we do a general adjudication, because those rights were never on the record. So we're going out and we're trying to find those rights, but people need to make those claims. So the historical case for adjudication, prior to the general adjudication or even the 1903 comprehensive water law, water rights kind of fell into 5 different categories. You had those that were decreed by ecclesiastical leaders, by religious fiat, those that were filed for record at the county, if you could ever find them. Rights that were decreed by the court, typically, and those were typically just between limited parties. They weren't comprehensive. They just were settling disputes among 2 different parties or multiple parties. You had contracts or agreements that were among limited parties as well, saying, hey, I'll take it here and you take it there, and they just kind of unilaterally entered this agreement with each other. And then you had those claims that never manifested themselves on the record, such as, you had a guy up in the hills diverting water, never felt like he had needed to file a claim, prior to 1930, or maybe someone who had a well prior to 1935 feel like they never had to file a claim because, they have their well. And so a general adjudication helps to kind of wrap those in. So as a result of these, the lack of definitive water law, there's a number of issues. First, there was no public record. And there certainly wasn't a consolidated public record where you could go and find all of this stuff, right? Because there was no record, there was rampant over-appropriations of the streams as well as the groundwater. And because rights weren't defined, there was a lot of controversy, a lot of fighting over water, a lot of lawsuits. And in or actually 1902, the state engineer made this comment. He made this observation. So remember, this is right before they passed the first comprehensive water law. He said, the definition of existing rights, meaning those rights that were already going on, weren't appropriated, they were just kind of grandfathered in, appears to be of first importance. This is not only necessary to pacify present contention, but to prevent future conflicts and encourage further progress. There can be no safe basis for future work before existing rights are known and made a public record. So the theory was, hey, we're going to adjudicate, we're going to get all these rights figured out, and then we're going to start appropriating new rights. That never really worked out. What happened is they just decided to start appropriating new rights, and they figured, oh, the adjudication will finally catch up. Well, here we are, over 100 years later, and we're still trying to catch up, right? And hopefully we're doing a better job we've expedited our process, and the legislature has been really good in providing us some additional resources to do that. So what is a general stream adjudication? Well, as I've already kind of hinted at, it's an action in state district court. It binds all water users, including the state engineer. So not just onesie-twosies who have a bone to pick. It's everyone in the basin. And it's governed, that's the section of code it's governed by. Some of the first general stream adjudications took place in the 20s, the Sevier and the Weber and the Virgin River. Those were all actually done. Keep in mind, in the 20s is back when you had the Depression was going on, and they had the Civilian Conservation Corps, and they had all these government work projects going on, so they just flooded these adjudications with personnel to get it done. Unfortunately, the Utah Lake Jordan River general adjudication didn't benefit from that because it wasn't started until 1944. So you can see that big purple blob kind of located in the upper central portion right here. That's the Utah Lake Jordan River general adjudication. So it's bigger than just Salt Lake Valley. It goes down into Utah Valley. It goes up into the Heber Valley. It's a huge drainage that includes the Provo River, the Spanish Fork River, all these drainages. And the theory was, well, we're going to get them all together because they're all kind of associated with this one main hydrologic system. Well, they realized that's just too hard to do. There's too many people. It's just too big a thing. So now we do subdivisions. So we're kind of taking bites out at a time. And that's what this is. This is the Oakland Place Subdivision of that big purple blob. All right, so why do we conduct general adjudications? Well, we want to bring all those claims onto permanent records. Remember, this guy is kind of using water without a need for a right. Either he has a surface right prior to 1903, which we call diligence claims, or an underground right prior to 1935. We typically call those underground water claims. You have these things called Federal Reserve rights, which I won't get into much in the weeds, but in essence, when there was a big Supreme Court case back at the turn of the century, there was a Fort Belknap Indian Reservation was trying to appropriate water rights to satisfy their needs as an Indian reservation. The state came back, as in Montana, the state came back and said, well, you're out of luck because we've already appropriated all these rights to all these other farmers around you, so there's no water for you. Well, they sued Montana, went to the Supreme Court. Supreme Court decided, well, by virtue of the fact that Congress had set aside this reservation, there was an implied water right associated with that reservation equal to the priority date of the reservation. And that has subsequently been evolved into any federal reservation has a similar Federal Reserve water right. So if you think of national parks, you think of Forest Service land, you think of national monuments, these all have these Federal Reserve water rights that can't be quantified because you can't sue the federal government, right? They got federal sovereign immunity. You can only sue them if they let you sue them, right? Well, in 1952, there was a Senator McCarran from Nevada who passed the law and said, hey, well, the states can sue the federal government and force them to quantify those Federal Reserve rights. And not only that, they can do it, and they can do it in state court, which is pretty unique to if you've ever tried to sue the federal government, it always has to go to a federal court. Well, this is the one scenario where the federal government has to come to the state district court and claim their water rights. Again, there's a lot more there. I won't get into it, but interesting stuff. Another reason why we do it, we prevent multiplicity of suits. We want to bring clarity to the water rights. We don't want people suing each other here and there. We just want to get it all done in one big suit and get it over with, kind of pull that hangnail off fast. We want to reduce or remove any rights that have been either abandoned or partially forfeited through non-use. And so let me talk a little bit to that. In Utah, or actually all of the Western United States, they have this concept of use it or lose it. And Utah follows the same rule. So if you don't use your water right in Utah for a period of 7 years or more, you are subject to losing that water right. The water right goes back to the public to be appropriated, right? And so that's the real danger here is if you have a water right, I would encourage you to get it up and running before we come out and evaluate the claim. So that, if we come out there and water's flowing, we're not going to go CSI on you and try to figure out when you started using it. We're just going to say, oh, looks good. Because we want people to use their water rights. We want them to put them to beneficial use. Did you have a question, sir?
I was just wondering if, I bought the house 15 years ago, and they weren't using the well when I bought it, but I've been using it ever since I've been there.
So his question was, he bought his house 15 years ago. They weren't using the well when he bought it. However, he's been using it for the last several years, 15 years or whatever, right? Yeah. What happens to me? And in my opinion, we're going to come and we're like, you're good to go.
Well, I was told that in the 40s they hooked everybody up to the public utilities and they made an agreement that they would cap their wells when they hooked up to.
So another statement, I'm just going to repeat it so everyone can hear. He had heard that there was an agreement back in the 40s that if we hooked you up, you would cap your well. I'm not privy to that agreement. I don't know anything about it. So as far as I know, if you have a water right and there's nothing on the record that indicates that this water right has been abandoned by virtue of this agreement, then we're going to say, good to go. We'll validate your claim and you're off to the races. But that doesn't mean we're going to do this type of thing, but we're not going to, we definitely want to give the benefit of the doubt to the water user who are actually using their water rights. Lastly, we want to obtain a final comprehensive decrees. So once we do this subdivision, we'll get a decree on this little bit, and then once we get all the little bits of that big purple adjudication blob, we'll get one final comprehensive decree. And hopefully that will be sooner than later, but hopefully it will be sooner than the next 100 years. All right, so the adjudication process is kind of a 3-phase process. The initial phases are kind of what we're doing here tonight. The petition to do the adjudication happened back in 1944, right? So we don't need to worry about that. Notices we've sent out, you've received the summons in the mail, and the public meeting is what we're doing tonight. The next steps consist of receiving a notice to file claims, and I'll go over this in greater detail here in a second. And those water rights that we have on our records for which we do not receive a claim will go on a thing called the list of unclaimed rights. That in essence means if people don't file these claims go on this list, and if someone doesn't file an objection to that list, those water rights are considered abandoned. So that's why it's important to file your claim. Yes, sir.
So about 3 slides ago, you showed that purple section of the state. Are there a certain number of water claims? Do you have we had 5,000, but we've appropriated 10,000?
So his question is, in that general adjudication area, that purple area, is there a set number of water rights or claims that we can have? And the answer is no and yes. There is no arbitrary number that we say we must have this many and any more than this is. But we have, in most of this area, stopped any new appropriations because the basin is over appropriated. And so what that means is we have water rights equaling this much, on paper. So if you add up everyone's water rights, paper water rights, it equals this much. However, there's only this much wet water in the basin. Acre feet. Yeah.
So you have this many acre feet appropriated, but there's only this much acre feet.
Right. So
doesn't that change that acre footage of water?
It may, but generally, so he's asking, doesn't that acre foot of available water change? Not very much, and not enough for us. If you really look at it, we have this much water, and we have this, 3 times the number of water, right? So it changes, but we do hydrologic modeling, and there's no magic way of suddenly saying there are so many acre feet of water in this basin down to the 1,000th decimal place, right? You have to do models, and there's a lot of estimation, a lot of engineering, and so it's it's a science, but it's an imperfect science. But the analysis that has been conducted suggests that we are severely over appropriated, and that's why there's no new appropriations permitted in this basin. In other basins, that's not the case. They can do small domestics. But throughout the state of Utah, there are a lot of basins that have been closed due to over-appropriation because we didn't have the science. The science lagged with respect to the concept of appropriation. So, list of unclaimed rights, you don't file a claim, goes away, right? We'll do another public meeting like this to explain it. The next step is, once we have all those claims that people have filed, we'll go out and actually investigate them. We'll evaluate them. And then we'll prepare a state engineer's recommendation that goes before the court in the form of what we call our proposed determination. Again, I will dive into the weeds much more on this, trying to give you an overview. That proposed determination goes to the court, and the court makes a ruling on it, and then that becomes what is used to distribute the waters from here on out. And it may adjudge some water rights being forfeited. It may adjudge in that list of unclaimed rights those water rights being abandoned. So it's a way of cleaning our records of water rights that are no longer being used and kind of getting a better sense so we can do better modeling and we can understand the overall picture. Okay, so let's talk about filing your water user's claim. So, and I can't remember if it's a week or 2 weeks. Mike, do you remember the date? The 29th of September. So on the 29th of September, that should be when it goes out. We will be sending out a notice. We go out to the same people who received this other notice about the public meeting, and it will be a notice to file your claims. All right. For those of you who, and we'll also, so we're going to send it out to property owners, and we're going to send it out to water right owners of records, and it will also be published in a newspaper saying, hey, this is the notice. Whether you guys read the legal notices of the newspaper or not, I guess, is debatable, but we do it just as kind of a measure. With that notice, we will include a water user's claim form. For those who are owners of water rights on our records, meaning we have a water right that we're tracking on our records, we will send a claim that's already filled out with what we think the water right looks like on our records. And you can simply look at that, and you can modify it if you so wish, line stuff out, or just simply sign it and then return it to us. And for property owners, for the vast majority of people, so keep in mind we have about 770 water rights of record in this book, in this area. We sent out 2,000 plus notices, so the vast majority of people will receive this other packet, which will have the notice and it'll have a blank water user's claim. Say that form, it's going to be a little bit intimidating to people who are maybe not familiar with this process. So I encourage you to bring that form in. If you feel like you have a water right you want to claim, bring it in and we will help you fill that out. But you need to bring it in and then you need to file it. You can file it with us or you can file it with the district court. It's easy to do with us. You simply bring it in or you mail it. But you have 90 days from the date of that notice to file that claim, all right? And so that notice is when we mail it out. So September 29th is the date that notice, that clock starts ticking, all right? So get on it. 90 days is probably plenty of time, hopefully. If it's not, you can email me or write me. My email address will be at the end of this presentation, or you can go to our website and it'll have a form. You can ask for an extension, and then by virtue of asking that extension, one 30-day extension is automatically granted. But that has to be done prior to the expiration of the 90-day period. So you have 90 days to file a claim. Yes, ma'am.
Does the water right typically go with the house when you sell the house?
That's a great question. Her question was, does the water right typically go with the house when you sell the house? In the state of Utah, it's assumed that the water rights are pertinent to the land. So it transfers via pertinence unless the deed is explicitly withholds that. So if I'm selling my house to you and I am silent on the deed with respect to water rights, it's assumed that transferred to you via appurtenance. However, if I'm selling my house to you and I say, I'm selling you my house, but I'm withholding this water right, then that did not transfer and I retain ownership on that. For the most part, what I've seen, people have just been silent on water rights, or they have blanket statements saying any and all water rights, ditches, all kinds of, boilerplate language that says you got whatever I had in the quitclaim deed. So the answer is probably the ownership of the water right probably did transfer with the property.
Lived out in the country and they didn't
Yeah, if you lived in the country and you didn't pass in the water rights, you wouldn't have any water, and then it's happened, right? It happens here too for people who are savvy enough or who want to do that. But for the most part, we don't see that as much. So once you file your claim, my staff, headed by Mike Handy. Oh, sorry. Yes, sir.
Situation here with a house or a plot that gets sold and then subdivided, 2 houses are built. What happens to the water right in that?
Okay, great question. So let me chase this down just the rabbit hole just a little bit further, and I'm not going to chase this thing any further on the title because we can get into some pretty complicated scenarios, and I'm certainly happy to chase those out. But his question was, all right, I own this parcel, it's 10-acre parcel. I sell it to someone else. That person or even I subdivide that parcel into multiple parcels. What happens to the water right that was associated with the original parcel? Well, if the deed is silent, well, the fact is all of those individual parcels probably own a part of that original water right. And you could update their title through what we call a report of conveyance. And that's a separate process, separate from the adjudication. They could update ownership to a fraction of that water right. Unless the person who subdivided it specifically says, I am going to give you all of the water right, Mr. Parcel A, and the rest of you are out of luck. And then he gets all of it, right? So it kind of depends on what the deed looks like. If it's silent, then they could potentially update to a portion of it. So, but we can talk, there are a million scenarios that have to do with title conveyances. And afterwards, if you have a specific one in mind, come talk to me, then we'll try to get your question answered. Come talk to the staff. We're pretty well versed. We're not title experts, but we can kind of give you an understanding of how the scenario might pan out. So, back to water users claims. Once those water users claims are filed, my team will take those claims and they'll go and evaluate them. Now, they typically try to contact the person who filed the claim prior to going out and reviewing it. We just find it's helpful for people to be on the ground to explain where their well is, how it's being used, rather than trying to assume one thing or another. Do you have a question, sir?
Yes. Is there a difference between a house that is historical, originally plumbed and have water coming in from the well, we discontinued because we rent it, and we still have a well in the yard for agricultural use, water well in the garden. Is there a difference between those 2 different uses?
So his question is, he had a house that was originally plumbed to take culinary water from the well and use inside the house. It has subsequently been severed, but they still use that well to irrigate the lawn. Is there a difference between those uses? Generally, what we see is when those water rights are established, they typically called domestic with incidental irrigation. So really what you're saying is part of the use of this water right is no longer valid. And what we'd say is, all right, the water right was originally appropriated with one house and so many acres of irrigation. We would come in and say, all right, the house is no longer being used. However, the irrigation is still being used. And so we'd recognize that component of the water right and recommend that to the judge that, hey, they're still using the irrigation portion of it. We recommend. Yeah, it may diminish the amount of water associated with the water right because part of the beneficial use has been abandoned, right? So yeah, it may.
I have one more question.
Sure.
Is there any history of any water contamination in that area, and where do we go to get our water tested?
So his question is there any history of water contamination and where do we go to get our water tested? I can't speak to that, to be honest with you. My first guess of where to send you would be to the Division of Environmental Quality, DEQ, and they're the Department of Environmental Quality, and then they have a division of drinking water and division of water quality. So you could go ask them, but that's a whole separate department.
I understand what you're talking about, but I was just wondering if you did it here.
No, we do not do it here. Yep. All right. Cleared hot to move on? All right, moving on. So our team will go out, investigate the uses, see that the well is still going. So, and I say this often during these public meetings, the hint is make sure your well's working when we get there. Now in the wintertime, it's probably not going to work, obviously, but make sure something's there, right? If there's time to repair the well, get repairing the well so it looks like so it's working. Okay, so that's kind of the stomp the heel, remember that key point of this presentation is when we come out to evaluate your water right, make sure there's something to evaluate, okay? Because if you file a claim and then say, oh, well, it's under the concrete driveway, but I still use it, yeah, it's going to be a heavy dose of skepticism on our part as to whether that's a valid claim. All right, so list of unclaimed rights. So you recall I talked about this list of unclaimed rights. So once that 90-day window is expired to file claims, we start compiling this list of unclaimed rights. And in essence, as I said before, it's all the water rights on record. So remember that block of 700 plus water rights we know exist. If there were no rights, if there were rights on that, in that block that there were no claims filed upon, they would go on this list. And they'd essentially list the water right number, the owner of record that we have on our records, and the point of diversion location. When we hold another public meeting like this, so we send out notice. So if you receive notice of this, even if you don't participate in filing a claim, you'll receive notice of the list of unclaimed rights and how to access it, so you know how to determine whether your right or your predecessor in interest was on this list. And we publish that, we send out notice, and we file it with the court. There's a 90-day window for people to object to the list of unclaimed rights. So if you see a right on there that you say, hey, that's my water right, and I did file a claim, or I'm excused because of some odd circumstance, and I do have a claim, you have an opportunity to file an objection. You have to do that with the district court, since now it's kind of in the court's hand. But at the same time, as you file that objection, you have to file your claim with it. And if you have any questions, there's only so much legal advice I'm comfortable in giving, so I encourage people with legal questions to seek competent legal counsel if you so deem that's necessary. If people file an objection, we've got to resolve it before the court can decree that list as abandoned, meaning we've got to, and generally what happens, if there's a legitimate excuse for why they didn't file their claim, we're simply going to tell the court, hey, that's fine, let them enter the claim and we'll evaluate it in the proposed determination. But it's got to be a legitimate excuse, right? It's not, I was too busy playing Xbox or something like that. We want it to be, hey, I just didn't get notice, or there was some other circumstance that just didn't allow me to get to it. Once the objections have been resolved, we petition the court to enter a decree, and that decree, in essence, adjudges all of those water rights on that list as abandoned, meaning they are no longer valid, they cannot be used, and they simply revert. Any water associated with those rights reverts back to the public to satisfy senior rights. Another part of the decree is we petition the court to prohibit any future pre-statutory claims being made, meaning this is your chance to file a claim. If you have a water right prior to 1930, or well that was prior to 1935, now is your chance, because if you wait until after this court issues the decree, you will be barred from making that claim, right? It's kind of the way of chopping us off so we can all move forward, saying these are the rights of record, so that there's some certainty moving forward. All right, the next step is the proposed determination. You recall we went out, we evaluated your claims. Now we put all our recommendations, we look at the claims, we say, well, he claimed this, but really he only has this, or he has this, he or she has that. And we make these recommendations, we publish it in this book called the Proposed Determination, and we send out notice. Now this notice will only go to those people who actually filed a claim, all right? And also to people who have a water right, to people who filed a claim, in essence. We'll hold another public meeting, kind of go over it. These are very rarely well attended. They do not, maybe 5 people usually show up to these things. This is usually the big one because you're all got that summons, right? So we hold a public meeting. There's another 90-day window to file an objection if you don't agree with what the state engineer, how he has recommended your water right. You file your objection with the district court. Again, we have to resolve that objection, and then we petition the court to enter a decree that confirms the proposed determination or modifies it based on whatever objection was filed. Decrees. In the early day, remember we have that big purple blob. The idea was to kind of get one decree that would rule them all. It's kind of like the Lord of the Rings. It's the decree that rules them all, right? Well, as it turns out, it's just too big of a subdivision, or too big of an area, so we're doing these small subdivisions. So we get these interlocutory or partial decrees at a bite at a time. Again, federal water rights are wrapped into that decree. We've already kind of discussed those. And then decrees often include language closing respective bases. Actually, you can ignore that. That happened in the list of unclaimed rights decrees, right? It used to be until recently the process was different. So you can ignore that last bullet. That's a holdover from a previous slide. So here is the Oakland Place proposed determination boundary. It's the same boundary that should be in the packet, the summons packet you received. It's bordered on the north by 21st South, on the east by 7th East, on the south by 27th South, and on the west by 3rd West. You see those cluster of green dots. It might be kind of hard to see. Those are all the wells or the water rights of records we are currently tracking. That's 700. Now, after this meeting, there will be some big aerial imagery plots with these dots superimposed on top of the aerial imagery. You can go and look. And I'll also show you a way of looking online at your specific house. So you don't have to kind of try to look at this and see, well, where's my house at. Better maps after this, and as well as I'll show you a process. 776 water rights of records. Most are underground wells. And there's the number of people we notified, 2,200 plus and minus. Okay, issues, out-of-date title to water rights on the state engineer records. So as many of you have highlighted or indicated, sometimes water rights transfer via purtenance. However, people who become the new owner of the water rights don't understand that they've got to update their title with the division of water rights. So on our records, that water right is still in the name of the original owner unless someone comes in and files a report of conveyance and updates it in their name. What's the benefit of updating the water right into your name? Well, you can only maintain your well or deepen your well or have a well driller come out and renovate your well if you are the owner of record for that water right associated with that well. So selling and filing change applications. So there's a host of number of things that you would be prohibited from doing unless the water right is updated in your name. Okay, the location of no proof required. So back during World War II, there weren't many men around to do proof. So the concept is if you appropriated a water right, you'd file an application, and then the state engineer requires you to file a proof saying, after so many years, saying, yes, I have developed this well, this is how I'm using it. And those proofs were typically done by engineers or surveyors. Well, in the 40s and 50s, there weren't a whole lot of those guys around, so the state legislature decided to say, we're just going to give everyone a pass. For a certain type of water right, a small domestic water right, you don't need to file proof, all right? And so the problem with that is great, really, because they didn't have to pay an engineer or a surveyor to file proof. However, the problem is that the locations of those wells associated with those types of water rights was never really squarely pinned down by an engineer or a surveyor. Consequently, some of these points of diversion that you'll see on these maps or these dots, they may not be very accurately located. So take them with a grain of salt. Just because it shows a well inside your doghouse doesn't mean that's where the well is going to be. It may not even be in your yard. It may be someone else's well. And so really how that's determined, the location of those is maybe a look through the record to look at the well driller's record, see what address is associated with that water right. So there's some other things we can do to kind of narrow down maybe where that water right is or what that water right is pertinent to. Yes, ma'am.
If there are two well access points on your property, but one is for the person next door to you, but the second one, the person next door to you has been capped, but yours is not, what does that determine? Who determines whose right or water right that is? How do you guys determine?
So the question is, on your particular, this lady's particular yard, there's two wells. Uh-huh. One maybe goes over and services the yard adjacent to you, and one is yours that you utilize, correct? However, the one that goes adjacent to you has been capped or plugged, or they don't use it or something to that effect. Yeah. What's probably happening is there may be two different water rights associated with that. And usually it depends a lot on what the appropriation looks like, because although the wells may be both located on your yard, the address of the appropriator of one of them may have the address of your neighbor. Okay. So there's some things to kind of figure this out, the end of the day, what you need to do is just file a claim or come in here and we'll help you figure out maybe which water right is associated with the well that you're talking about, and then make sure that number is associated with your claim. Otherwise, file a claim and we'll figure it out, though. Okay.
A lot of homes in Salt Lake have dual access, like their sewer mains and their water lines, so could be one well just feeding up, feeding two homes.
Yeah, so he makes a good point. There are some instances where you have multiple houses utilizing one well. And it's possible to have more than one water right in one well. It's also possible to have one well with one water right servicing multiple houses. So we just need to kind of take a look at it, see what category these fall into, and come up with the best solution. So there's no automatic, if you have two wells, you have two water rights. You may or may not, but sometimes you have one well with multiple water rights, satisfying different houses. So
can you file a claim for both of those, or just the one that you're using?
So the question is, can I file a claim for both of those or just the one I'm using? You can file a claim for whatever you want to file a claim for. It's your claim, right? At the end of the day, we're going to come out and evaluate your claims. And if only one's being used, we're going to recommend that the other claim be disallowed. Okay. So feel free to claim, what you think is you need to claim. At the end of the day, we can't force you to claim anything or can't force how your claim looks. We can certainly return the claim if it doesn't meet the statutory requirements, the description necessary. But if you come in and work with us, we'll make sure that it meets that requirement. Some of the timeline, 90-day claim filing period begins at the end of this month. You'll receive that notice in the mail. In December, that 90-day claim filing period will conclude. In March, we will hopefully publish the list of unclaimed rights. Then you have that 90-day objection period for the list of unclaimed rights, which will conclude in June 2018. And we're back here a year from now talking about the proposed determination, publishing that, and initiating that 90-day period, and that 90-day period wrapping up in February of 2019. So you can see this is a long process. It takes a lot of time and the reason that is because it's purposefully architected that way in order to provide due process to the water users, because we don't want to take water rights away where there are valid rights. And so they have all these checks and balances in it. Yes, sir.
If I'm understanding this is for unclaimed. If we're relatively sure we have a deed and we would claim it, is it a shorter determination?
No, so at the end of the day, it's that proposed determination that says this is what the water right is. Yeah, so that's when that 90-day, so we should publish the proposed determination around this time next year, maybe November 2018. And in that, if you file a claim and it's a valid water right and we come out and we say it's valid, that's what we'll kind of say, hey, this is my water right, it's good to go. And then unless there's an objection on it, you can kind of take that to the bank for the most part. So maybe November of 2018 is kind of your golden hour when your water right becomes magic, I guess. Yes?
I've seen something that was written up about our water rights. Is that what tells how much water we get, or is it how much is trickling out now through the rest of the
So her question is, she's seen some write-up that kind of delineates what her water right is, and so her question is that how much we get, or is that how much? So help me, Ben, with your second part.
I'm wondering how you determine the acre feet.
Okay. So her question is, how do you determine the acre fee? How do you determine the extent of this? Well, really what happens is we get your claim, we go out to your yard in this case, and if you're using it for irrigation, we look for all the green grass we can find, then on using ArcGIS and using aerial imagery, we map that, and it comes out to so many acres, or a quarter acre, or a tenth of acre, or whatever. And then there are some equations we use to determine the amount of water necessary to be diverted for beneficial use, for irrigation, or for domestic uses. We have these quantities. So in this part of the valley, for irrigation, we say you need 5 acre feet per acre. So ignore that and just say you need 5-foot column of water to be applied on an annual basis to grow grass. Now, only half of that's actually consumed, but we simply say, so if you have an acre of yard, you would need 5 acre feet, if you can kind of follow in my math here, of water to satisfy the irrigation demands of that lawn. Now, that's kind of the quick and dirty, right? It's going to be a little bit more nuanced than that. But at the end of the day, it's also limited based on what your appropriation is. So it's going to, so you might, your water right may only be for 1/10 of an acre. And just because you're irrigating a 1/4 acre doesn't mean suddenly now your water right is for a 1/4 acre. It's whatever the original appropriation limitations applied. So it'll only be 1/10 of an acre. So there's some other variables that come into play, but we know how to quantify the acre foot amount depending on the beneficial uses associated with the water right. Did that answer your question in a complicated enough way? Did I cloud your question enough to obfuscate? So her question is, yeah, we're in the 1930s, that'd make us secondary. Don't worry about secondary or primary. What you're asking is, that would make us pre-statutory. It's probably what you're asking. Okay, great question. So the question is, can I dig deeper if it runs dry? If you update title and you have a water right, you can renovate that well and drill as deep as you need to drill to seek after the water. And actually, kind of court case precedence is that that's your obligation, because if someone drills a well next to you and lowers the groundwater surface, the court has said, well, it's your duty to seek the water. It's down there. You just got to drill deeper. So that's just Utah case law for you. Yeah, so if the state wants to suck it, well, I'm sure there are a lot of people that would tell the state to suck it, but I think the state's not really in the business of sucking. It's mostly the public water supplier that would be sucking, right? But yeah, in essence, that's true, and it has happened to a lot of people that states or the public water suppliers or public municipalities drill big wells. They take a lot of water to satisfy peak demands, and the water table has dissipated. And our response is, go after the water. You know, there's always an opportunity when those water rights are appropriated by the municipality to say, that will impair my right. You can always weigh that. But for the most part, all these municipalities have bought old irrigation rights that are well established. And so the opportunity to claim impairment is kind of out of the. Yes, sir.
So if you do your due diligence and get your claim in and everything's good, can you move that well to a totally different location from where it is?
It's a good question. So he's asking it, if you do your due diligence, you file your claim, it gets recognized in the proposed determination, can you move the location of that well? And you can. It's through a process called a change application, and that's a different process, and there's going to be requirements. And part of those requirements, people are going to get notice of that, and if they say, no, that will impair me, that will impair my water rights, the state engineer can always reject that application. But yeah, you can move those, and there's certain restrictions depending on where the well is located and how much water and where you're moving it to. But that's really the only way to get a new water right in this valley, right, is to get it from someone else and then move it. And so that's understood. It's just a different process. Yes, sir.
The crystal ball question, since the Wasatch Front population is supposed to double by 2040 or so, the water table is probably going to drop.
So his question is, since the Wasatch Front's, the population in Utah is supposed to double by 2040, right? Most of that along the Wasatch Front. The conclusion is that the water table is probably going to continue to drop. Yes, but there's a glimmer of hope in that the governor has directed the state engineer to manage groundwater in such a way to attain a sustainable yield, meaning that used to not be the case. However, that's part of the state engineer's obligation now, is to avoid drawdown. And I'll let Kent talk that if he wants to talk that, is that kind of generally correct, Kent, as far as the governor directing us to maintain a sustainable yield in water?
By statute, we are to regulate groundwater based on safe yield, which is what the annual recharge coming into the basin. So, if we find that water is being taken faster than the water is being supplied each year, then we will set up a groundwater management area. We have to come in, our only authority to regulate is to regulate them by priority. And so we go into those areas, we identify the rights we're pulling out of the groundwater, and we will make a list of those rights, and the junior rights, the one that have the latest, or
The more recent priority.
that's what priority that we would come back and say, okay, you need to stop using your water now, and we would just keep moving through those rights until the groundwater gets stabilized. So it's all based on priority when that water is first put to use, but we have that authority and responsibility then to come into the basins and regulate based on these groundwater management plans.
And we've done that in different places in the state, but to your point, it brings up a big question: where are we going to get our water from, right? And that's part of this. We got to figure out, well, what waters do we have? What water rights are charging against our bank account? But it's a dilemma, and there's a lot of people trying to figure that out. Most of them, the ones that are really trying to figure it out, are these water conservancy districts who are required to provide the water to that growing demand. But at the end of the day, if you don't have the water, you can't do the growth. So, I think it's kind of one of these self-regulation. They can project all they want, but at the end of the day, if you ain't got the water, ain't no one growing.
Pump all the water out the ground, it seems.
Yeah, there's subsidence issues, but yeah. Okay, I'm just get through this slide, and then I think that's the last slide, okay? And then those who want to leave can pick up and leave, and then I'll continue to answer questions. So a lot of questions is, will I lose my water right? Again, those who are currently using their water right in conformance with the records on the Division of Water Rights don't really have anything to worry about as long as they continue to do that and they file their claim within the prescribed time frame. Individuals using water without a water right record are required to submit a claim during the process or risk being barred from future assertions. So like I said, if you have a well prior to 1935 and you fail to file your claim now, tough luck, Chuck. We got to drive on. At some point, we got to move on to the other part of the county and start adjudicating that. If the water use authorized under the water rights fallen out of use for 7 years or more, the water right or portion of it may be recommended be disallowed in the proposed determination. We kind of tucked in that. If you have a water right for a house and irrigation and you stop using the house, we're going to say that part has been disallowed. Or if you have a water right for a house and a yard and you've capped the well and it hasn't been used for 7 years, we're just going to say that water right has been disallowed, it's been forfeited, and the water associated with that right reverts back to the public. All right. That is the last slide. I'm happy to answer questions. Yes, sir.
Most of what I've heard has been about wells. We live in a neighborhood, our family's been there for 100 years. At one point, there was an irrigation ditch that ran behind all the homes on the block, and we all shared that water. It was a cutoff over on Simpson Avenue. It's been years, but that all stopped flowing.
That's not the big ditch, is it?
You're in Parley's Creek on Simpson. We're on 60s.
Is that a Parley's Creek thing? Well, so, yeah, why don't you get with this gentleman right here and he can help explain that. All right. Any other questions, sir? The grandfather years are 1903 for surface water, so if you divert it off of a stream or a spring. For underground waters, it's 1935. Well, we could start looking at the month when this came out, but I think we're pretty, if you say 1935, what's that?
1935, September 15th.
Yeah, I think we probably would do one of these and just kind of, all right, 1935. Well, we'd look at it. I mean, I'm not gonna, say that we're gonna violate the law, but we'll take a close look at it. I bet we can figure something out. Yes, sir, in the back, and then I come to you.
Where does South Salt Lake, the city of South Salt Lake, currently get its water from?
His question is, where does the city of South Salt Lake currently get its water from? If I were to guess, I'm not an employee of South Salt Lake, nor do I have a very good understanding, but I believe they have a series of wells that they divert their water from. Maybe. It doesn't necessarily need to be within their city limits. It could. It could get it out of Parley's Creek, or yeah. Again, I'm not very familiar with the water rights of South Salt Lake City. If you are interested in those, I suggest you maybe contact them and ask them about it. Yes, sir.
How do you regulate what the right is once it's been determined?
So this question, how do you regulate what the water right is once it's been determined? The answer is we don't. We first, we don't have the manpower. We do have an enforcement engineer, one for the entire state. So if a neighbor doesn't like you and wants to send in an enforcement action, they can do that, and then we'll investigate it. But at the end of the day, it's really, this is your right, be good type of thing. Go forth and don't break the law.
I might know the answer. Can you clarify this? So if we have water rights, just assume that we had water rights, but the building or the agricultural area was plumbed using culinary water from the city. Do you automatically give those up if we haven't used them in 7 years?
So this question really boils down to, if I haven't used my water rights in 7 years, do I lose them? Yes. Regardless of the circumstances.
But it said may, it didn't say for sure.
Yeah, that's just because I like to soften up that so people don't get pissed off. But yeah, pretty much that's the case. You're probably going to, if you haven't used your water rights in 7 years, they are subject to forfeiture. There are some extenuating circumstances.
But it's because,
One of the circumstances might be if the stream wasn't able to provide water within that 7 years, that doesn't count towards forfeiture.
well, we go from the 1850s to the 30s and technology and pumps and cleanliness of water, and all of a sudden it's much more convenient to build a home or a business and plumb the water in, but then you're paying fair market value for what you think. Well, I've got water rights, but we're not. Most of us aren't farming anymore, so we still SOL on that.
Yes, you are SOL, I guess. It's hard, it's a case-by-case situation, but at the end of the day, if you aren't using your water rights for a period of 7 years or more, you are subject to forfeiture. There are some extenuating circumstances, but those rarely apply in these types of situations.
Just that the property was valued, or as I said.
We can talk one-on-one. Let me help answer some of these questions. Yes, sir, in the back.
If the title is out of date, can that be updated during this process, or is that a separate thing?
His question is if the title's out of date, can it be updated during this process? It can. It may not. We will continue to move on, and it can continue to update. They're two parallel processes that aren't reliant on each other. So you could start it before, you could start it during, you could start it after, and hopefully, if everything works out how it's supposed to, it shouldn't make a difference. Okay. Yes, ma'am.
When he talked about who comes first and we're going to start shutting off rights, is that done within our subdivision or within the purple block?
It would be within, so our question is, when we're talking about these groundwater management plans, what's the boundary associated with those? Is it the subdivision that we're talking about, or is it the big purple blob? And really, it may be both, it may be neither. Right, not won't be both, but it may be either, it may be neither. It's probably more dependent on, hey, what does this aquifer look like? And they're going to draw a line around the aquifer, say, all right, within this region, because we do have potential or proposed groundwater management plans within the Utah Lake Jordan River general adjudication already underway, okay? And so it's just going to depend on, because to do a targeted study, doing a study of groundwater, I know it sounds really easy, but there's a lot of, it's pretty hefty analysis and modeling involved. And so usually what they do is they get a hydrologic unit or an aquifer and model that, and then that becomes the basis for their groundwater management plan, because they need to understand how much water is coming into the aquifer, how much water is moving through the aquifer and going out, and how much water is being pumped up. And so they have all these variables they got to figure it out. So the quick answer to your question is it's probably going to depend on whatever the aquifer looks like.
Well, what I'm getting at is South Salt Lake was settled later than Salt Lake City. So if we're putting in with Salt Lake City, the Salt Lake City people are gonna get first dibs, and we're all gonna be.
So yeah, your question is, or statement is, Salt Lake City was settled before South Salt Lake City. So really how these groundwater management plans typically go is they come to a consensus on how to do it. So water users typically find a way to make this work before they have to start cutting off by priority. I wouldn't lay awake at night worrying about your domestic well being cut off by priority. So if I can give you any semblance of comfort, there are a lot worse things to worry about, including just driving home tonight than what we're talking about here. I haven't seen that where that's the case. But yeah, in theory is the junior priority rights would be cut off first. But usually it's really politically unsavvy to start killing grandma's well to her house because it was drilled in 1935 for a golf course as a well that was drilled in 1905. So you got to understand it's a process that takes a lot of dynamic variables into consideration. So don't worry about it at this point. Just continue to use your water, and I think you'll be all right. All right. Was there some more questions? Yes, sir.
I know we used to beat this horse to death, but one particular question in relation to this process, and for instance, if a well was dug in 1928, if there were no rights placed upon it, you go through this process, you finally get the rights on it. Does that well become like a brand new well in the eyes of water management, or does it recognize the initial well drilling date?
It's a great question. So this question is, if a well was drilled in 1928 and it had no appropriation or water right associated with it, and then we go through this process and he files a claim and then given a water right number, what is the priority date of that water right? Is it today or is it 1928? The answer is it's 1928. It's when it was first put to beneficial use. Yes, sir, in the back. So the question is, I bought a new property, has a well on it. The rights probably belong to the property with which the well came on, as opposed to associated with my first lot, right? That's probably the case, but we can figure that out. And really, if you're using the well, that's the most important thing. We can figure out that other stuff, but the most important thing is that water is being placed to beneficial use to preserve it. Because even if it's being put to beneficial use somewhere where it's not authorized to be put beneficial use, the court has said that preserves it from forfeiture. So we would look at that to make sure that, hey, this guy needs to file a change application, but his right is still legitimate, type of thing. That's kind of the approach we take. Yes, sir. I do. There's a map outside of them, and then I was going to go through and show you how to access that on the interface once I kind of get the bulk of the questions resolved. Yes?
Map of green dots, I put my property up on the online map, and none of the green dots are on my property, but we pump water for culinary and irrigation.
Okay.
So how do I figure out which of those green dots on somebody else's property is mine?
So her question is, she looked it up on the interface, didn't find any wells associated with her property, and she's curious, but she does use the well and pump it for culinary and for irrigation. Was your house built in 1935 or prior? Okay. So it may not be on our records. And so what you need to do is file a claim. And if you can show that your house is built in 1932, that's too easy, right? la-di-da-di, we'll figure it out. It just may not be a water right of record. They may have just failed to file that claim. So we can look around. What we'll end up doing, if you come in with a claim form, we'll kind of pick some of those water rights and just see in the general vicinity, see if they may be yours. And if none of them are, you'll just file a blank claim and it becomes a new water right. It has a new water right number associated with it. And it comes its own green dot.
So it won't be like the 1928 claim, it would be a brand new one.
No, it'll be like you'll have a new file jacket number with a big number, but the priority date will be 1932. Right.
What's the website I can look at?
It's right here, www.waterrights.utah.gov.
Yeah, that's what I wanted to ask you, if there was history of when the well was drilled, who owned it? Do you have any record of that?
So yes, do we have a history of when water rights or when wells are drilled? We do have some. So if we have a water right of record, you go and I can show that to you. The scanned documents, we have we have upstairs just a big room like this with all these file jackets of water rights. But online, we have all the documents in those file jackets scanned and accessible to the public. So if you find a water right, you can click on it and you can find some of these like well logs and even historical deeds and stuff like that. You looked for it, but you never found it?
Yeah, I was just wondering if there was, if it existed.
It may not. Some of these records are pretty sparse. Some of them have more than others, so it just kind of depends. Let me turn on the Wi-Fi here. Yes.
You were saying if it's before 1935 as well, it's grandfathered in.
Yes.
And then if you have a water right number, but if the title or it hasn't been updated necessarily, but it hasn't been excluded either, is it considered grandfathered in if you updated it or?
So our question is, so you have this water right. You've seen it has a water right number, just it's not in your name, right? So what you would do is you would file a claim on that water right number and say, that's the water right number I'm claiming, okay? And then you're good to go, and then you can update title later or during if you want to, but just file a claim on that water right.
But do I have to have like the engineer come out?
Her question is, do I still have to have the engineer come out? We have to come out and evaluate it. So we'll come out. I mean, it doesn't cost you anything. It'll just be us knocking on your door. Hey, we got your claim. We see what you've claimed. We see you have a well. We just like take a look around, take a picture of the well, make sure it's still functioning, do our due diligence, and then we make that recommendation. Follow on question?
So we bought our house, and the lady who lived there before was using it, and then they remodeled. We bought it from somebody who remodeled, and they capped it, but it hasn't been over 7 years. Can we re-access that well? Get it back up and running?
Yeah. So it hasn't been 7 years since it's been capped. What I would recommend is if you have, because we're going to come out and we're going to say, well, it's capped. What are you using it for? It's going to be hard for us to, justify a claim on that. So there's two avenues you can take here. One of them is the preferred. Uncap it, put a hose bib on it, throw a sprinkler out on your lawn, have a nice day, right? The other option is provide us certifiable proof of when that was capped. But again, answer A is the best answer in that situation. Keep on. Go ahead, sir.
Is there something like to put a cap on? Is that just the basic plumber that you can call and do that? Or is it an engineer behind?
You mean to uncap it or to cap it? I'm having an internal struggle by, it's like the do-it-yourself guy versus the guy that wants to follow the law type of thing. And, I'm just going to say this. If it looks like something you could, in theory, you're supposed to have a well driller renovate a well, but
It's not like opening a fire hydrant where water's going to come shooting out of it.
I don't know. It probably won't be like a fire hydrant. It might be like a little, a gurgling hose maybe this time of year, if anything this time of year really. But if it were me and it was just a pipe sticking up with a cap on it, I'd get it, get a hose bib, and that's what I would do. But that's just me. And I'm not telling you what to do. But because the problem is, if you try to get a well driller out to come and do it, they're going to say, well, you're the owner of the water right. And then you got to update title, and that takes long. And then we're going to come out and evaluate it, and we're going to see it's capped. And so we kind of get into this, well, it might be forfeited. So, and then you've spent all this money, and plus well drillers are super expensive. I'm sorry, I'm trying to pull up the internet that's here. Let's see if I can get it to. Yeah, okay, let's try a different browser, see if that wants to play. All right. So, I'm going to go take you through to show you how to access the interface and then how to look at a water right and find some scanned documents on the water right file. What's that? It's not hard. Don't listen to that. It's easy. All right. So, yeah, I totally get it. It may not be super intuitive, but you're going to think it's hard until you try to go to a different state and try to do the same thing, and then you'll come back and just think, oh man, we have it so good. So here's how you get to it. All right. The easiest way to identify if you have a water right in your property is go to Data, go down to GIS and Maps, select that link. Go up here in the upper left-hand corner to Water Right Maps. Select that. And then you just go to this top one if you want to. Really, most of these all kind of go to the same place, but just to keep it easy, adjudication areas. We're doing adjudication. Why not? Let's do that. And then you wait. My hotspot's not super fast, so hopefully your internet's faster than mine. Okay, see all these purple squiggly lines? Well, those, remember the big purple blobs, general adjudications? These are all the subdivisions within those big blobs. So we're going to zoom in to our particular subdivision, okay? And it's with a mouse pad, not super easy. All right, see this little square right here? See all these? These are all other subdivisions we've been doing. This little rectangle is the one we're talking about, Oakland Place. And you guys know why you're so small compared to the other ones? Because you got so many doggone water rights inside that little square that we had to shrink it down. Okay. And I usually zoom in a little bit. So if you go over to this side menu on the right-hand side, and you hit points of diversion. Remember what points of diversion are? When I say points of diversion, what do you guys think? Wells. We think wells. That's the answer. That's the correct answer. You know when they say there's nothing, no wrong answers? That's not true in this case. So those are all the wells. See all those clusters? So it can kind of get pretty clouded or crowded in there at that scale. So I usually zoom in, and let's just go down to one of these avenues and just kind of. Yeah, they do. So you can see the 57 is the prefix, the area number, and then the water right number is after the dash. So we look at this house, which is 164 on whatever street this is. I can catch the avenue. It's somewhere. And if you wanted to see what this water right was all about, and I just lost it. So we're looking at 575083. You can select that, and I'll bring up this little menu. And it'll kind of give you a summary of the status is it's underground water claim, meaning it's one of those pre-statutory rights. It was drilled in 1910. The current owner is J.E. Salisbury. The point of diversion location is that public land survey system, which I won't get into, but if you want to ask, we can talk about that later. And then if you select this little hyperlink up at top, this will take you to our database for this particular water right. So I'm going to select the hyperlink.
Now, is that
That's the owner that we have on our records.
Okay.
That may be a dude who's been dead for 50 years, but he's the last person who updated his information with us. The current owner is whoever is the owner of the water. So you got to kind of distinguish. The county recorder is the place of record for all property. And so really whoever is the owner of the water right is determined by the deeds and conveyances associated with that property, or even maybe this particular water right. So here's what a water right looks like on our database. You can see the name, the address of the original appropriator. In this case, the address is the same as the house that resides there. So that's pretty easy, right? You look down here, it's filed in 1936. That means that's when the underground water claim was filed. He was claiming that the well was drilled in 1910. So that's the priority date, it's 1910. Even though they didn't get around to filing it, because remember, they didn't have to file until after 1935. Here's the flow rate. In this case, these wells were measured in cubic feet per second. That was kind of the preferred method of the day. When we adjudicate this, we'll probably change that to an acre-foot quantity based on the beneficial uses. The beneficial uses are listed down here. In this case, see, this must have been, so I'm looking at this, the irrigation for 290 acres. So what that tells me is this may have been a well associated with one of the big original survey, or big field surveys where they had, when it was still kind of field growing alfalfa or whatever, right? Obviously, today, they wouldn't get 290.4 irrigation acres. They'd probably get whatever irrigation was in their yard, assuming they still have the well, assuming they file a claim. We'd cut them down like an acre, quarter acre, whatever their property is. The domestic, 0.6 EDUs, they used to say, how many people do you have drinking from this well? And people would say, well, 3 people or 7 people. Today, we just have a domestic unit. So in truth, although it says, so EDU stands for equivalent domestic unit, what it means is it's a house, right? And so we look at that and say, well, it's really meant to be a house, so this is probably just one domestic unit. They may have said, I only have 3 people. But in truth, they have a house, a residence. And so in our opinion, that's one domestic unit. So when we adjudicate this, we might change that to say 1 domestic unit and quarter acre of irrigation. And that's what we'd recommend to the court. This is just an example, but that's the type of thing. Assuming that their house was still connected to this well and they were using this well to irrigate their property. The place of use, this is, again, the public land survey system. It kind of divides it into 40-acre tracts associated with sections. I'm not going to get into the weeds on that, but if you're interested, you can come talk to me later about it. Kind of running out of time, but I'm happy to stick around. So that is how to access that interface. Oh, one thing I do want to show you, scan documents. So if you go to this drop-down and you select scan documents, it'll bring up all the documents that we have in the file for this particular water right. Here, it's not very much. We have the well record sheet, a field data sheet, and the original underground water claim, which I presume this is the first of it, so we can open it, and this will show what the person filed in 1936 claiming. And these can be helpful to kind of figure out what were they truly trying to do, and why were they trying to irrigate 160 acres or something in downtown Salt Lake. But in any case, you can see it's a black iron pipe, 2 inches in diameter. It's hard for me to imagine that irrigating over 100 acres, but that's what they claimed. So that's the first page of it. We go back to the second page. And these were scanned back in the day where you could only scan 1 sheet at a time. So more modern scanning will have 1 document with multiple pages. Here it says the priority date, the maximum water diverted, and other notes. Okay? So that's just an example of this particular water right.
Yeah, I was wondering, you said 15 gallons per minute, and we don't measure it by standing there and holding it. The gallons of water per minute. We just go by authorized.
So his question is, these days we don't quantify in gallons per minute or cubic feet per second. We can still quantify in those measurements. The statute specifies cubic feet per second and acre feet. And we typically, to aid our modeling of this area, we will typically say an acre foot volume, because it's hard to say the CFS because you're not using that number, that flow rate 24/7, 365, right? You're not using it 24 hours a day, 7 days a week, 365 a year. And so it's hard to say that's how much water, because if you ran out 15 gallons per minute every second of the year, it'd be this huge block of water. But we're saying, well, that's not really what they're using. What they're really using is this much for irrigation and this much for the domestic. Sir?
I have a fish pond, and I use mine, and it constant flows,
Mm-hmm.
and it drains back down into the ground.
Mm-hmm.
So I do use mine 24/7, 365 days.
Okay. And so that may be the case where a CFS flow rate is justifiable.
Because I have to have that, because it always drains back down into the ground.
Yeah.
They wouldn't cause a sinkhole, ground collapse.
So
Mine does that too.
would it cause a sinkhole? Or, well, we don't live in karst topography, so thank goodness I don't think we're in danger of limestone dissolving beneath our houses and not disappearing in the middle of the night. But did you have a question?
Yeah. What happens to my working well if I don't go through the process of renewal? Do they come out and cap it?
What happens to his working well if he flouts the state engineer's notice and decides I'm going to do my own thing? Well, any water right you had would be lost. But no, we're not going to come out and cap it unless your neighbor rats you out and says, hey, he's using water without a water right. Then we'd come, all right, let's go take care of this minuscule amount of water in the grand scheme of things because a neighbor complained. But so that answer your question.
So if you don't have the right, you're using the well, then she gets you.
Yeah, if she doesn't get you, so I'll get to it. Let me just, so the enforcement action, it could be, it depends on the infraction, depends on the amount, and there's certain statutory provisions. And I'm not in enforcement. I prefer things to stay out of that realm. But there's some teeth. There's like third class levels of misdemeanor associated with it. I mean, it's a criminal offense. So, yes. Will you be charged taxes on this water? No. There's not to my knowledge. I mean, you're taxed for water you get from the public water supplier, but as far as your well goes, the only thing I can think of is any property tax associated that would enhance the value of your property, and I don't think they take wells into consideration. But no, there's no annual fee or anything like that.
What about liability from damage my water might cause? Like if my water floods my neighbor's basement?
So she asked about liability. Liability is liability, and if you flood someone's basement, then you're probably liable. And there's nothing that we don't insulate anyone from liability. You're not insulated by virtue of having a water right. You still gotta. So I don't think we don't deal in liability. Let's put it that way. So I'd seek legal counsel on that, I guess, is my default answer. Any other questions? Adjudication related? Yes, sir. It'd be preferable to make an appointment just so that we can have the team who's out here operating this area work with you. However, if you just can't make an appointment and you just walk in, we'll hook you up. We'll figure it out. We got plenty of staff. We're set up to do that. But always to make an appointment is so much easier because then we can get the file, we can read the file, we can do some initial research so that when you come, you don't have to spend as long. We've already done that initial research. So, any other questions?
One more.
All right.
Okay, you determine the rate, acre feet and all that. We don't have to make that determination.
Yeah, this question is, so do I have to quantify the acre feet or the CFS or the gallons per minute? No, we come out and it's really going to be based on what your beneficial use is, and that's because we'll say, all right, so many acres of irrigation, so many chickens, so many horses, right? That's this amount of water. Yeah. We do that. You can make a claim. You can put it on your claim. We understand that's not intuitive to a lot of people, so we don't really hold people's feet to that. But keep in mind, it's going to be based on what was initially appropriated, right? It's just not, I'm going to suddenly bring in 10,000 head of stock onto my quarter-acre parcel so I can expand my water right? Yeah, it'd be tough to get them in there. But so, any other questions? All right, thank you very much. There's should be some maps outside. Take a look, and some staff to answer your questions.